Welcome to the Risky Healthcare Business Podcast, where we help you prepare for the future by sharing stories, insights, and skills from expert voices in and around the United States healthcare world, with a mission to inform, educate, and help healthcare organizations and individuals ranging from one doctor practices to large integrated systems and organizations throughout the dental, medical, and veterinary healthcare industry with risk, while hopefully having some fun along the way. I'm your host, Scott Nelson, a guy that grew up in Ohio and has been working all over the United States during my 20-plus year and counting career in the healthcare industry, with a commitment to accelerating healthcare performance through creativity, not just productivity. Let's dive in. Non-compete agreements in healthcare are legal provisions that restrict the ability of healthcare professionals to work in certain competitive environments after leaving their current employer. Initially designed to protect healthcare organizations from scenarios like losing sensitive information and investment in employee training, these clauses have sparked a significant debate over their impact on the industry and its workers, as well as the quality of care provided to patients. The primary goal of a non-compete agreement in healthcare, as in other industries, is to protect the business interests of healthcare providers by restricting the ability of their employees to join or start competing entities within a certain geographic area and for a specific period after leaving employment. In theory, non-compete clauses safeguard a healthcare entity's investments in their staff, intellectual property, proprietary information, and other confidential information and business interests, such as unique treatment methods or patient retention strategies that could potentially give competitors an advantage. Additionally, these agreements can serve to maintain a stable workforce by deterring employees from leaving abruptly and ensure that the investments made in the employee training and development yield returns for a reasonable duration. Non-compete clauses help prevent situations where a departing healthcare professional might take with them not only intimate knowledge of the operational practices and strategic initiatives of their former employers, but also potentially siphon off patients to a new practice, thereby directly affecting the former employer's market share and revenue. On April 23, 2024, the Federal Trade Commission voted to finalize a new rule to prohibit employers from enforcing non-competes against workers. According to the FTC, 1 in 5 Americans, totaling nearly 30 million people, are subject to non-competes. The Commission determined that non-competes are an unfair method to competition and therefore violate Section 5 of the Federal Trade Commission Act. The final rule prohibits employers from entering into new non-competes with workers on or after the effective date. The rule also prohibits employers from enforcing existing non-competes with workers other than senior executives. Proponents of this decision feel that non-compete agreements can hinder career progression for healthcare professionals, limit patient choice, and potentially drive up healthcare costs by reducing competition. In some regions, these agreements have created scenarios where specialists are scarce, affecting patient access to timely and essential care. Moreover, such restrictions can lead to a concentration of talent in larger systems that dominate the market, stifling innovation and diluting the quality of healthcare services. The American Hospital Association, a critic of the FTC's decision and rule, said in a statement, "The only saving grace is that this rule will likely be short-lived, with courts almost certain to stop it before it can do damage to hospitals' ability to care for their patients and communities." Recent legislative actions in the federal government and various states have aimed to limit or ban the enforcement of non-compete clauses in healthcare, reflecting a growing recognition of their potential harm to both healthcare providers and consumers. As the healthcare industry continues to evolve, the balance between protecting business interests and ensuring an open, competitive market for healthcare services remains a contentious and critical issue. In this episode, I'm speaking with Kim Ruppel about non-compete agreements and risk in healthcare. Kim is a partner at Dickinson Wright in Michigan and chair of Dickinson Wright's healthcare litigation and telehealth task forces. Kim has over 20 years' experience as a commercial litigator who represents healthcare providers, insurers, and benefit plans in health contract litigations, including enforcing and defending non-compete agreements, licensing and regulatory disputes, governmental fraud and abuse investigations, HIPAA compliance counseling, and insurance claims and coverage disputes. Let's talk with Kim about non-compete agreements and risk in healthcare. Kim, welcome to the show.
Thanks, Scott. Happy to be here.
Before we begin our conversation about risk in healthcare and non-competes, I'd like to take a moment to talk about your background and work. What is your work in healthcare as an attorney?
I am primarily a litigator, which is why I'm working on non-compete related issues. But I also deal with regulatory compliance, licensing investigations, general governmental investigations, and counseling. So counseling healthcare clients on risk avoidance and also defense of litigation, sometimes on the affirmative side as well.
In general, how do you view and think about risk in healthcare?
Always top of mind, to be honest. Whether it's risk from the just practice of medicine to from the patient care perspective, the quality of care, that's always top of mind. Patient care is a number one priority for our healthcare clients. Absolutely. But then also the risk involved in healthcare regulatory scheme is very big. The healthcare providers are mainly focused on providing quality healthcare and often don't realize the extent that the federal and state governments are involved in regulating their practice. That's where we come in and try to give advice and help them stay out of trouble.
With potential for the federal government or state governments to get involved, why is it important to think about risk? What are examples of potential risk? What should individuals and organizations be thinking about?
Well, the risk is inherent in the way that the practices have financial arrangements, so that when a physician is involved in any kind of financial arrangement with whether it's an employment arrangement, whether it's a contract with another practice, there's always the risk that Stark or anti-kickback issues will come up. Those are federal laws, but most states have similar laws. And those laws basically prohibit a physician from accepting what's known as a kickback, a financial remuneration for referring patients, for referring business based on the volume or value of their services. Those are the things that government tends to frown on, and with the idea that will improve patient quality and prevent providers from, trying to put profit above patient care.
Transitioning to non-competes, let's start with a history and general education background. What are non-competes and how did we get here today?
Non-competes, the real basic idea is preventing someone from being employed in a similar context. When the government gets involved in this way that the FTC has just recently, what they're trying to do is prevent unfair competition. And I stress the unfair because businesses compete all the time. And that is sort of the nature of our American capitalist system. So it's the unfair part that we're focusing on. In 2021, the executive branch issued an executive order that said non-competes were disfavored and that the federal agencies would begin to develop these kinds of guidance that is coming down now. So it's been a couple of years, obviously, since the executive branch took a stand on this. And now we finally got the agency, the FTC anyway, is involved in issuing its guidance. The DOJ and NLRB likely will as well, but this is the sort of the first step.
According to the FTC in a recent fact sheet about non-competes, roughly 1 in 5 Americans, totaling nearly 30 million people, are subject to non-competes. The American Medical Association says between 37% and 45% of physicians are affected by non-competes. So who has them and who's involved in a non-compete?
I think the most common would be the hospital that employs physicians and would want to prevent their employed physicians from leaving work and going to work for a neighboring hospital. Probably a very common scenario. And the concern would be not only the physician would be taking patients with them, might take knowledge of a business strategy, expansion perhaps, or any kind of different practice area that it would be pursued, and just any kind of general confidential information. So that's what we see most commonly as far as the employment on the physician and provider side.
Why have non-competes? What is the risk in having or not having a non-compete? One might argue from an individual perspective, there's risk in having a non-compete because it limits opportunities. And from the organizational position, there's risk in not having a non-compete because of potentially taking patients and confidential information such as business strategy. Where is risk with a non-compete?
That's the push-pull, right? So the individual provider doesn't want to be limited from, performing his or her clinical services anywhere that they want. But the main objective, I think, from the employer side is to protect its, as you mentioned, intellectual property, patient lists, confidential information, business strategy, and even just depending on the employer, if there is any kind of financial investment in the physician with respect to training or sign-on bonus or payment of continuing ed expenses, that kind of thing. So where the employer is putting additional money into and as an investment into its employees, it wants to, protect that investment.
Let's get into the recent FTC decision and final rule on noncompetes. On April 23rd, the Federal Trade Commission voted 3-2 to finalize a new rule that prohibits employers from entering into new noncompetes with workers on or after the effective date, and also prohibits employers from enforcing existing noncompetes with workers other than senior executives. Of the approximately 26,000 comments the FTC received on the new rule, a significant number came from healthcare employees, especially doctors. What happened to get to this decision, and what does it mean for healthcare professionals and organizations?
I'm not surprised at the number of comments in that proportion, because I think that it does affect healthcare probably as much or more as many other sectors. And for that reason, I think it's very important to the healthcare sector. I will say that from the perspective of nonprofit institutions, as most hospitals are, the FTC does acknowledge that it doesn't have authority over those entities, except to the extent that they might also have financial arrangements with, say, a for-profit physician practice, for example, which is often the case. But the fact of the matter is, a lot of physicians do work for multiple employers. A physician may have his or her own private practice, also do rounds at a hospital, and may also want to do rounds at another neighboring hospital. And so if they are restricted by a non-compete provision, they're limited in where they can work. And from the individual physician perspective, that limits their patient care, that limits their income, and is just a practical hassle, really.
Does this decision decrease, increase, or create risk to individuals and organizations in healthcare?
Frankly, I think it increases the risk, certainly until everything sort of settles down and there's a general understanding of what will and will not be enforced, right? So the FTC rule isn't effective currently. The issuance of the rule is effective now. It's been published, which means that in 120 days or September of this year, the rule will be effective. However, there are also multiple lawsuits that have been filed almost immediately after the rule was announced. And it remains to be seen how those lawsuits will play out, which will probably take anywhere from a year to 2 before there might be a determination whether the FTC actually has the authority to issue this guidance. So there's that. And then what do healthcare providers do in that interim? I've had lots of clients ask me that already. And frankly, I think that the best way to go forward is to continue doing what they've been doing with the understanding that a non-compete might not be effective as long as they think it will be. And then there are other protections that can be applied in the interim to hopefully mitigate that risk.
Thinking about the phrase letter of the law versus spirit of the law with 3 parts of this decision and final rule. The first being the final rule prohibits employers from enforcing non-competes with workers other than senior executives. And the final rule defines senior executive as workers earning more than $151,164 who are in a policy-making position, president, CEO, or equivalent roles, if they have final authority, not limited to merely advising. Is this a broad take and open to interpretation? I've seen individuals and organizations across the country that overtitle, undertitle, and positions outside of the senior executive position, so director and manager level positions, that make more than $151,164 and could be argued are in a policy-making position over a department or a division. To me, this final rule seems very broad and open to interpretation.
Absolutely. I'm sure that the FTC will issue some regulations that will hopefully clarify and maybe, solidify what that means. But in the meantime, employers really are going to have to try to figure that out as best they can. And maybe that's something that will be baked into an employment agreement. This is a policymaking position. The salary amount, the compensation amounts could be set based on the number that is in this rule, which to me seems a bit artificial, right? So, but it's playing the game. It's following the rules. And if the employers can determine who their policy making official or executives, right, are, then that takes a little bit of the gray out of the argument. But that's something that I think probably will be subject to litigation unless there's a little bit more clarification as to what that means.
The second letter versus spirit part is section 910.3 of the final rule that talks about exceptions. And there are two that I noted. One is this final rule does not apply to the sale of a business entity, and the other is if it's inapplicable. There are always potential exceptions to rules, but these two strike me as the sale exception attempting to differentiate and separate just one group from the rest in this remedy. And the inapplicable exception, again, strikes me as broad and open to interpretation.
Right, right. I do think that it makes sense, this exception, to be honest, because what the FTC has stated that it's trying to do is to prevent unfair competition in an employment context. So when you're talking about the sale of a business, that's a little different animal and is a transaction that is between two willing participants that should be, anyway, negotiating and bargaining at arm's length. When an employer and employee aren't necessarily on equal playing fields. So the FTC is trying to be more protective in that situation. When you've got a sale, that the non-compete provisions are important to the purchaser generally more often because they want to make sure that what they're purchasing, they're not going to have somebody coming in to interfere with their new business by either taking away their employees or just competing in another way. So when the sale happens, the non-competes follow typically to the purchasing entity so that they can maintain that their business expectation of what they believe that they're purchasing.
If I'm a doctor, a physician, or a dentist, or a veterinarian, and I'm an owner and selling my business, and I now have a non-compete with the buyer, which becomes the new owner, does a non-compete extend to the staff or solely with the seller and previous owner?
That would depend on the situation, I believe, because oftentimes in a practice, maybe it's the physicians, the dentists, the vets that are restricted by the non-compete, but the administrative staff are not typically. But there might also be some sort of non-solicitation provision so that the medical professionals might be restricted from soliciting employees of the former entity, unless they, were going along with the transaction.
The applicability of this exception, when it's inapplicable, what are possible examples? How would one define that and say, well, this situation doesn't fall under this rule?
So one of the exceptions is really kind of a retroactivity idea, and that's common in most statutes or most regulations where the rule is effective going forward. So the rule is not going to go backwards in time and say, okay, all of these lawsuits that are already pending throughout the country challenging non-competes, we're going to wipe those out. And I think that from a fairness perspective makes sense to me because there are different scenarios and different non-competes that may be challenged throughout the country that the FTC isn't trying to come in and say, we're going to wipe all that slate clean.
The third and final letter versus spirit part that jumped out to me is section 910.4a of the final rule, which states that it won't limit or affect enforcement of state laws. Is this something that as a federal rule, organizations and entities could utilize creative solutions and move this into a state situation and bypass the FTC rule and make it a state issue?
It could. I mean, that provision I thought was a little confusing, to be honest, because they're saying that the FTC rule will not apply to state laws, but the federal rule or the final FTC rule will preempt state laws that conflict. So I guess what they're saying is, states, you can go ahead and, develop your own laws or sets of rules as long as it doesn't conflict with what we've said.
Considering this final rule in its entirety, what are your thoughts as it moves forward in healthcare?
It is a very broad rule, I think. It gives very little discretion to, like I said, parties that are bargaining at arm's length on equal playing field. A physician who's just coming out of medical school, for example, is looking to get a job and probably has no bargaining power with respect to where, they're negotiating for employment, which is different than, say, somebody who's been practicing for a decade or more and, has an established practice and maybe is a medical director running a clinic, et cetera, and they might have a little bit more bargaining power with an employer. So the final rule doesn't give any kind of discretion in those two scenarios. A lot of state laws are different, and I'm from Michigan, so Michigan's rule is basically one of reason, so that non-compete provisions, as long as they're reasonable, and that's obviously subject to interpretation, they can be enforced. Not to say that all are. So there are other states that prohibit all non-competes entirely, and I think that the FTC has sort of leaned that way. But I think that it's gonna take some time to figure out exactly how that applies.
Will this FTC decision have significant impact in healthcare, and potentially how much? You'd mentioned the FTC jurisdiction and that it doesn't apply to all organizations. You'd also mentioned lawsuits. The American Hospital Association is a critic of this rule and the decision, and said in a statement that the only saving grace is that this rule will likely be short-lived, with courts almost certain to stop it before it can do damage to hospitals' ability to care for their patients and communities. In your opinion, how significant is this rule? How much impact will it have, and how much will it help?
If the rule stands, I think it will have significant impact. It could lead to, hospitals not being able to protect their own economic and patient interests and intellectual property, et cetera. I think that there are ways to, mitigate that, certainly. But if this broad of a rule is applied and enforced and remains in effect, I think it will have significant impact. From the individual provider perspective, that may be a better position, because individual providers will be able to leave jobs with some more ease, but there still would be restrictions that would, I'm sure, come into play.
Along the lines of your previous comment about people and organizations continuing to do what they've been doing and see how things settle down and will be enforced, what can individuals and organizations be doing proactively? Or what if there are organizations and individuals that have not been doing anything? What are some things they could or should be doing to protect themselves?
Certainly, confidentiality agreements in employment agreements, I think, is absolute. That protects the employer from the physician or anybody else leaving and discussing information that should be maintained within the organization. Same goes for non-disclosure agreements, similar concept, where there's defined information, the definition being in the employment agreement. That information cannot be shared or disclosed in any fashion. The intellectual property, that can be also protected in a separate way, where it's not part of a non-compete, it's part of an employment agreement. You're not allowed to share this intellectual property of the organization, that sort of thing. Something that we're using also is a little bit more of a short-term fix, but certainly on the hiring side, if there is a, say, sign-on or commencement bonus paid, that, a physician could be asked to sign a promissory note to repay that amount if they don't stay the length of term that they're signed up for. So that if they leave, they have a 2-year agreement, they leave after year 1, they pay back half of their bonus, and that can be a financial incentive for somebody to stay for the length of their term.
What are potential obstacles that doctors, healthcare professionals, and organizations may face with this new rule or non-competes in general? What can be done to work through and pass those?
Where I see the problems with our clients is everybody, the hospitals in particular, physician practices, always looking to acquire quality talent, right? And to acquire quality talent, you've got to be competitive, and you've got to present an attractive offer. And sometimes to retain people, the employer might have to consider whether the non-compete could be forgiven or lessened. Maybe you do let the physician work at a hospital that's maybe not next door, but, a certain distance away that doesn't interfere with business. And that way you're able to retain the desired physician. It's all about setting out expectations from the get-go, and whether that's in an employment agreement as a contract, a policy guideline that an employer might require employees to agree to certain set policies, that sort of thing. But I think that communication is the key. Transparency is very important. And, just thinking ahead a little bit, and certainly engaging your legal counsel.
You had an interesting point earlier about people wanting to enforce these if they wanted to walk away from a non-compete. Over the last few years, I've seen a change with individuals and organizations on both sides of non-competes. Several years ago, if a person left, the employer might make an effort to enforce a non-compete, depending on the situation, and think about if that's something they wanted to take on or let go. Over the last 1 to 2 years, as courts began to strike down non-competes, more organizations decided not to enforce a non-compete or fight it.
That makes sense to me too. I've seen that, and I think there's a business decision to be made, right? Like, is a hospital going to file a lawsuit and sue its former physician? And then there's legal risk in that, there's financial risk in that, and there's the public relations risk in that. Suing doctors doesn't always look so good when the public is like, why are you suing my doctor? I just want him or her to take care of me. I don't want, to have to worry about what hospital he or she is aligned with. So there's certainly that thinking does come into play when considering the risk of litigation with the non-compete. And also that can be negotiated without litigation, right? So if a physician wants to leave, another hospital wants to hire that physician away, there can be negotiation about maybe a buyout scenario that acknowledges the former employer's investment in the physician and the value that the physician is bringing to the new employer.
So there are additional or alternative solutions that do not include or are outside of a non-compete to resolve these types of situations, such as the negotiated settlement example?
Absolutely. And sometimes what I see too are the non-competes restricting a physician from clinical activities versus administrative. So a physician could be employed to oversee, say, a practice area within a hospital or within just a private practice. And they're performing an administrative function rather than a clinical function. And that's distinguished in a non-compete. And so courts don't like to limit where physicians can actually practice medicine. However, there's a little bit of a difference that, I've seen courts treat with the administrative practice. So there's 2 different ways to look at things as far as that goes. And I've also seen non-competes that contain provisions where if an employer terminates the physician without cause, then the non-compete goes away, which is the right thing to do, right? If there's somebody that's, you've been fired and now you're going to be held to a 2-year non-compete, that doesn't seem fundamentally fair. So many non-competes contain that kind of a restriction or limitation.
Do you expect this to be the evolution of non-competes into something else, creating alternative solutions or replacements, or no impact at all? For example, if non-competes go away, could there be an increase in utilization and change in strategy for non-disclosure agreements and other protections for intellectual property and confidential information?
What I could also see, what I have seen is sort of a no-poach agreement between employers, so that one hospital makes an agreement with the hospital down the road that we won't take your doctors for this long after they've left your employment. Okay, fine. That could be enforceable because, again, that is an arm's length negotiation between equal, bargaining players. However, there is an issue, there can be the issue there with an antitrust consideration, so that depending on how broad that restriction is, if it is truly limiting the flow of employment, then I could see the DOJ coming in and the governmental agencies coming in to say, no, that is an unfair restriction as well.
Looking forward into the future of risk in healthcare and expanding beyond risk with non-competes, how can organizations and individuals be prepared?
I think examining the contracts that they have currently, knowing the developments of the law to be able to stay ahead of it. And like I said, even with the FTC rule, for example, this may not really be effective for, say, a couple of years until the lawsuits have concluded. But knowing what the FTC has in mind and trying to stay ahead of that, I think that is best practice to try to, create your contracts or revise your contracts accordingly and, be prepared to be able to protect the organization or protect your individual clients as well.
That's a great point to conclude our conversation. Kim, thank you very much for your time and sharing your thoughts and experiences today. I really appreciate it.
Thanks, Scott. Happy to do it.
Thank you for listening to the Risky Healthcare Business Podcast. You can listen to all episodes from the Resource Center page of the SpringParker website, springparker.com, or click the listen link in the show notes to listen and subscribe for free on your platform of choice. And remember, accelerating healthcare performance is achieved through creativity, not just productivity.